Professor Turley, many of the unilateral actions the Obama administration has taken addressed controversial political issues, effectively cutting the people's elected representatives in Congress out of the political process for a whole host of important issues. What is the effect on the political process of having the executive branch alone make these tough decisions? Is unilateral decision-making good for our Republican system of government?
Well, thank you, Mr. Chairman. The greatest danger that we have really cannot be overstated when you have the concentration of power in one branch. That is precisely the danger that the framers were seeking to avoid. People like James Madison viewed the branches as sort of like bodies in orbit. They were locked in an orbit of shared powers. Once you have a concentration of authority in any one branch, it creates instability. But what people often miss is that separation of powers is really not about protecting Congress, about the institutional powers. Separation of powers was designed as a protection of liberty. It was to prevent the concentration of power by any of the branches that would threaten individual citizens.
Professor Foley, can you elaborate on what long-term institutional consequences would likely be if the current practice of benevolent suspensions of the law isn't stopped?
It's a really good question, because I think, if Congress can't stop the President from these benevolent suspensions, I think the first thing that occurs to me is that people are going to become very cynical about government. They already are, but it's going to get worse. And particularly, I think people are going to get very cynical about the Constitution. They're going to start thinking that law is politics. I already have students in my classes who think that, and it gets worse and worse every year because of situations like this. Situations like this, these benevolent suspensions, as they get more and more frequent and more aggressive, they're eroding our citizens' respect for the rule of law. We are a country of law and not men. The other problem I would see from your perspective, if I were sitting on the other side, is that, it's going to render Congress superfluous, right? You have a delicate situation here, I understand, but think about whether or not you would ever want to tackle any super controversial issues if this continues. Because think about, for example, comprehensive immigration reform. Why would you go to the trouble of reaching a very delicate political compromise on an issue like that if you actually think the President is just going to, simply benevolently suspend those portions of the law he doesn't like after you reach that compromise? So if you want to stay relevant as an institution, I would suggest that you not stand idly by and let the President take your power away.
As Mr. Schroeder has noted, the President certainly has some discretion to set enforcement priorities in order to best allocate limited resources and to make a case-by-case enforcement decision. But does that discretion encompass the complete non-enforcement of multiple statutes without any argument that they are unconstitutional? Ms. Foley?
You're talking about the just discretion to not enforce something? Could you repeat the question? Because
Sure.
I got a little long there around the margins.
I apologize, but
right.
we acknowledge, as Professor Schroeder noted, that the President has some discretion on case-by-case enforcement decisions, but the question is, does that discretion encompass complete non-enforcement of multiple statutes without any argument that they are unconstitutional?
Yeah, of course it doesn't. There's a difference between enforcement discretion and non-enforcement of the law with regard to an entire category of people. Enforcement discretion, for example, is when a prosecutor with limited resources says, you know what, I've got all these cases lined up, and I think I've got the best evidence to spend my limited resources prosecuting this one first, this one second, this one third. Prosecutorial discretion is not saying, well, I know I have this law and I know it says it shall do this and it shall do that, but I'm just going to say it doesn't do that with regard to an entire category of people. That's an apple and an orange. And this is not a simple matter of enforcement discretion. This is suspension of the law with regard to an entire category of people.
Professor Turley, it would appear that the largest impediment to Congress seeking judicial review of the President's failures to faithfully execute the laws is the doctrine of standing, which according to the Court is a doctrine required by the separation of powers. At what point must the separation of powers principles that standing is intended to preserve give way to the separation of powers concerns a congressional lawsuit would be intended to enforce?
Well, it's an excellent question, Mr. Chairman. I have to say that I believe the Supreme Court has made an unholy mess out of the area of standing, and many of our problems are attributed to the fact that they've left the two branches to fight out in sort of raw power, as opposed to resolving what are not political questions but structural ones. And I've long believed, and I've represented members of this committee and other committees challenging presidential action, that member standing would go a long way to resolve some of these conflicts. They would not fester. Whatever the framers may have meant in the first three articles of the Constitution, it can't possibly be this. It can't possibly be a standing principle where literally no one seems to have standing to bring an issue before the court. And it can't possibly mean that a president can go to Congress and ask for something, be rejected, and then use his unilateral authority to achieve the same result. Those things to me seem quite beyond the pale of anyone that looks at the Constitutional Convention.
I thank the gentleman for yielding to me, and Ms. Foley, in following up on the discussion that the gentleman from California just had with Mr. Schroeder, the argument is made that deferred action on a whole category of people, somewhere between 500,000 and 1 million people, is acceptable. Now, the principle on which that is founded is prosecutorial discretion. Has prosecutorial discretion such elasticity that an entire category of people could be recipients of deferred action simply based upon their being in the category, when the Congress has on the books for many, many years laws signed into law by Presidents of the United States, made it illegal for those people to be present in the United States? Aren't we talking about here the exception swallowing the rule when you essentially carve out the vast majority of people in the category to have deferred action?
Yeah, I mean, this is sort of a dangerous and scary moment. That's not discretion. I mean, that's raw lawmaking power is what that sounds like to me. Think about what discretion is. Discretion inherently by the executive is a case-by-case decision, just like a U.S. attorney makes discretions as to whom to prosecute first. And I believe Mr. Schroeder a second ago mentioned equity. We're trying to do equity here. And equity itself is inherently individualized. When courts exercise equity powers, the whole point of equity is to do an individualized case-by-case assessment as to what is right. That is not what President Obama is doing. He's not doing case-by-case assessment. He's doing entire categories with a giant magisterial brush. He's wiping out an entire category of people to whom the law applies. In my book, that cannot possibly be characterized as prosecutorial discretion.
And there's a great debate going on here in the Congress right now about what the appropriate action is to be taken with regard to children brought here illegally by their parents. Isn't the whole point of that if the Congress doesn't act and the President is impatient with that does he somehow have the power to reinterpret the law and stretch the meaning of deferred prosecution to say, well, I'm going to effectively create a new law by allowing 500,000 to 1 million people to remain here in a deferred action legal status that the law was never intended to provide for?
Well, let's hope not, right? And I'm sure if you ask the American people, they would say that's not their understanding of what the president is supposed to do when he's charged under Article 2 with faithful execution of the law. And as Professor Turley pointed out a second ago, when the president does something like that, where he proposes a legislative reform to a law to Congress, and Congress discusses and debates it extensively and rejects his proposal, and then he turns around and through, again, executive order, his own unilateral act, decides to simply implement those reform proposals by himself without congressional authorization. That's the worst possible fact pattern. I cannot imagine that a court looking at that fact pattern would say, that's just prosecutorial discretion.